My name is Suzanne Clark. I am on the board of directors of ACEDS Jacksonville, and our ACEDS Jacksonville eDiscovery Day presentation is with Chad Roberts on electronic medical records pain points in practice. As some of you know in our audience, Chad Roberts and I have worked together for many years. He is one of my closest colleagues, a mentor. Most of what I know, if I look at what my knowledge base is, comes
Scary.
from Chad.
Scary.
Maybe over 50%. So Chad has done a lot of work over the years in MedMal. And that's just an area of personal injury law that Chad has an expertise in. And he also is ACEDS certified. He's an RCA, Relativity Certified Administrator, so he has a lot of expertise in eDiscovery as well. So we are going to be talking about electronic medical records and their overlap with eDiscovery. Chad has worked for Holland & Knight for a decade, I believe. He's worked for Sporer Dodd, which is plaintiff side firm. And since 2013, I believe, he has been the owner and managing partner of eDiscovery Co-Counsel, PLLC. eDiscovery Co-Counsel co-counsels with plaintiffs firms to help them with their eDiscovery. So Chad, take it away. Thank you very much for being here with us today. I'll be monitoring the chat. If you have any questions, I'll monitor the chat and ask Chad your questions.
Yeah, I appreciate it. Do I sound okay?
Yes.
Good. So based on the size of us, just we can let some of the questions and comments as they filter in sort of, throttle the level of detail that we try to get into today. One of the reasons this is titled Pain Points and Practice is that presently in this area, there's some pain points without doubt in electronic medical records. Whether you're a plaintiff's lawyer or not, or you work for a plaintiff's law firm or not, you're eventually going to cross paths with this real thorny issue. And the purpose of today is so that you can leave kind of knowing what the landscape is and know, issue spotting. If you can do nothing more after today's visit with us together, is spot the issues that you need to worry about and spot the potholes that you need to worry about. It's a complex area, and what we'll try to do today, there we go, is generally the setup is, one of the big issues is how to get them. It sounds trite, and it all sounds very boring until it's not, and you have a problem trying to get them. But a lot of the jurisprudence about electronic medical records right now goes to the tortured history of how to get electronic medical records and who has to pay for electronic medical records and how much they have to pay for electronic medical records. And then because we're all in the electronic discovery space, we need to give some measure of sensitivity to how we handle them. There's a lot of urban legends about HIPAA and what HIPAA means, and people invoke it for all kinds of reasons, sometimes legitimately, sometimes not. But we're generally all aware that there's some heightened scrutiny of sensitivity about personal health information. And then we'll talk about how to use them. So if I could, if you have an issue about getting electronic medical records, either your own or your clients or someone you represent or someone else, the obstacles and roadblocks that are going to be thrown up at you have a history of their own. And so I just need to sort of kind of bring you along historically to the federal overlay that applies to getting medical records. So it presently is a very complex and still unsettled federal overlaying state regulations of getting currently electronic medical records. And we are presently, as we sit today, right in the middle of a brand new transitional period of all those federal regulations and how they're going to apply to us going forward. But the history of how we got there is going to inform the issues you're going to have in the future. So let me just do a real quick overview of them. The primary statutes and acts that need to be on your landscape are the old historical 1996 HIPAA Act. We've all heard of HIPAA. 2009 was the HITECH Act. That was part of when we had the Great Recession, it was part of the stimulus bill, and Congress incentivized healthcare providers to get rid of that paper and go electronic, and they gave money to people for doing it, and also baked in some rules about our own access to our own electronic medical records. And then HHS, Health and Human Services, published some enacting Code of Federal Regulations that interpreted those two acts. And the most controversial things were how they interpreted who can ask for them and who has to pay and how much. And the issue became a person asking for their own medical records gets a super good guy rate under those two statutes. It's labor only, or $6.50, or some other objective criteria, but it's modest, and it can't. You don't have to pay for a cast of thousands to go search and collect, for example. You can only be charged the labor of just basically sending them to you. But did that apply when you did that on behalf of your clients? And law firms said, of course it does. We're just doing this on behalf of our client. Our client gets a good guy rate, and we should get the good guy rate. And then it turns out that most of the healthcare industry uses third-party providers to just do this service that they contract of collecting your medical records and sending them to you. So one of those providers, SCIOX, successfully challenged the interpretation, HHS's interpretation of that, and had a lot of that overruled. And so there's a famous decision and order in the SCIOX case that is now part of the law you're going to have to deal with and navigate. Just some vocabulary that we need to have when we talk about electronic medical records. And there's four that I think, or there's four here that I think would get you started when you read these things. The first two are old HIPAA terms, and they're a covered entity and a business associate of a covered entity. So when we as electronic discovery users, handlers, HIPAA, this thing we've always heard about, actually only applies to essentially healthcare providers, right? Really professional healthcare people. And that the obligations that apply to a covered entity can be enlarged to some of their business associates who by necessity must handle their clients' and patients' protected health information. So as an illustration, if someone were to walk up to you and hand them your stack of electronic medical records, their own, and you left them on the bus stop and they showed up on the internet, it's not a HIPAA violation. It's just an old-fashioned data breach because you're really not subject to HIPAA. So what we have to do typically as electronic discovery helpers of people, we typically need to be a business associate of whoever we're handling that for, and it's actually required that you have a written business associate agreement with a covered entity that may be your client, and Health and Human Services has a great form template for that. The other two things that are the fuss of this vocabulary that's discussed about electronic health records, and I promise we're 2/3 of the way through this ugly history, is the third-party directive, and that's the common, there are millions of these transactions every day. By volume, it is one of the most important electronic discovery transactions that occurs. People asking for the electronic medical records, but those requests are usually made by a third party on behalf of a person, their lawyer or their business or whatever. So a person that's receiving someone else's electronic health records on their behalf is called a third party. And when the requester directs that it go to a third party, it's a third party directive. And the patient rate is the super good guy statutory rate that applies to people asking for their own healthcare records. And it's a very low rate by public policy. It's regulated to be very low. And it's what the industry that monetizes dispersing electronic health records tries to avoid. So the cat and mouse game is you need to request electronic health records, and you're going to be dealing with someone who wants to avoid the patient rate. All right. So anyway, so this was the history, and we get to this, the landmark electronic medical record case of SIOX. And it basically said, third parties don't get the good guy rate necessarily. And it only applies to electronic healthcare records, not any other format. And so, all the regulations that said your lawyer gets the patient rate was disturbed greatly by the SIOX decision. So that's out there. And what happened, and this is the current website for Health and Human Services, and they give a little notice about how they're going to interpret the laws now, and they give you a copy of the SIOX decision and tell you to read it and be familiar with it. And if you do, you'll have the whole ugly history of it so far. The issue though is, while the SIOX decision just came out recently, just as recently, Congress had enacted a thing called the Cures Act, and HHS was enacting its own rules for the Cures Act, and it supersedes and fixes a lot of the failures that SIOX successfully challenged in that decision. So we're right in the middle of the Cures Act being implemented. That is really, and when they decided they're going to fix it, they really fixed it or changed it and addressed all these issues, big important policy issues. So if you get objections, you're going to have people cite to the SIOX decision and say, here's why you don't get these medical records. But you need to be aware that there's something new on the block called the Cures Act. And just this past May of last year, Health and Human Services published their rules about this. So, and it's being implemented now. So I promise this is the ugly history part of all the rules and regulations. So the most significant thing is that what's on its way is a patient portal. And hopefully we're going to just avoid all of this cat and mouse about who pays for stuff. There's going to be a patient portal for healthcare providers that they have a time frame that they have to implement. And you can go on to the patient portal and you can get your own medical records, including your diagnostic images, the audit logs. Ooh, that's a big one. Ask me about that sometime, Suzanne, when you get a chance. Ask me about audit logs and a lot of other cool stuff. And so hopefully there's help on the way. But for now, if you have a client that needs their medical records, ask for it directly from the patient, not from your law firm or whatever your entity is. Send it directly to the healthcare provider, not its outsourced contractor. Have it delivered directly to your client in an electronic format, and that will generally get you the good guy rate and get you where you need to be. Does that make sense so far?
Yes.
And by the way, if you need a template for requesting this and one that recites and refers to the HITECH Act and HIPAA compliant and all that stuff, just email me and I can get you hooked up with that. But
we had a question which you just answered with this slide, but I'll go ahead and just let you know there's audience participation here.
Good.
Why can't patients or their representatives request records, or does that not meet legal constraints when used in litigation? And then another follow-up question: if patients request their records, is there the danger of the patient modifying the records?
Great question. So that goes to evidence integrity. That's a great question. So, so the way it's handled typically in litigation is that if you're requesting this through litigation and through the discovery process, those rules apply. So the typical scenario is you're trying to figure out in plaintiff's world, for example, that creates the highest volume of these. So someone's in a motorcycle accident and they hire an attorney to, represent them in their motorcycle accident or whatever, or that any litigation where their personal health is at issue. Sometimes you're trying to collect that before litigation and you don't have the power of a subpoena or process or anything like that. And so these regimes speak to people outside of the litigation dispute environment, trying to get their patients. Once you're in, there's an exception in the acts for legally compelled electronic medical records, and you can get a lot more at that point through the legal process, if that makes sense.
But you have to have filed your complaint.
Yes. Yeah. Okay. So the issues that are left
and then did you answer the question about modifying?
No.
That's the self-collection issue of
No, I didn't, because I forgot.
To us. Right.
So typically once you're in litigation and you have to have a forensically defensible copy of your electronic medical records, you really do that just like all of the other things we get in electronic discovery. So you can do, for example, the hard way, if you just have to do it 3 yards in a cloud of dust, is you go do a third-party records custodial deposition of the healthcare provider and have it be ducis tecum, and they come and testify that these are business records made contemporaneously with your care and treatment, and it's been collected that way and says all the magic words for a business record exception of the hearsay rule typically, and it gets marked as an exhibit and bait stamped, and kaboom. Then you have a forensically certified copy that comes directly from the healthcare provider. Interesting always to compare what you get before litigation with what you get after litigation. Okay?
Yes.
Yeah. Word to the wise. Word to the wise. Many a case has been cracked open by unexplained differences between requests that happen before litigation, kind of under the radar screen of a routine request, and then a production that occurs in, which is a great segue into
Are you
the
talking
next.
about gaps in productions by the
Yes.
producing party?
Well, yes, and just differences. The best way, sleuthing around in litigation where your healthcare records matter, is that typically your healthcare records are shared with your other healthcare providers. So sometimes your orthopedic guy will need a copy of your endocrinologist records to make sure you're good for surgery to have your hip replaced, for example. And they'll ask for a copy of the records. And you'll look at what they got doctor to doctor, which is routine, and then you can see what they got when you ask for it in litigation. And many a case has been cracked wide open by mischief that occurs when they think their thing matters, which is why we're talking to audit logs. Ask me about that.
Right. So the audit log, tell us about that.
So here's what everybody should know, is that since 2009, paper charts are in our recent history, but they're pretty much gone. And just about every kind of claim you'd ever want to have that is not barred by some statute of repose, unless it's a minor child, for which the statute can be told for a great many years. They're all going to be electronic health records. And if there's anything I would just emphasize to folks, is this notion, and it happens to us in our routine electronic discovery as well. The notion of a page is just meaningless now, right? There was a time when you could measure the size of your electronic health record in terms of the number of pages, but it's now just a big SQL database. In fact, many different SQL databases. And the notion of a page is meaningless largely, which is why people get gouged for the fights over costs, like we sent you 10,000 pages of your medical record and we're going to charge you $1 a page under the state statute. You can make things come out to be many pages when you want to print them and format them that way, right? So here's what's going on in the background of all electronic medical records. And I say all, and I'm pretty confidently saying all, and here's why. In 2009, for everyone to get a subsidy to transition from paper to electronic healthcare records, they had to get a certified electronic medical record system that had, term of art, meaningful use. And you couldn't get certified unless it has an audit feature running in the background of the software. And the government's interest in this was to prevent Medicare fraud, largely because they would say, you're kind of upcharging us, kind of running the meter pretty hard on your Medicare bills and your Medicaid bills. We'd like to see a chart where those charges can be substantiated, and people will go, oh no, and they let's spruce it up a little here and add a few more diagnostic findings to make that procedure justified and things like that. So to be a certified electronic medical record now, there has to be an audit feature running in the back. Most healthcare providers don't know that it's running in the back. Some do, many don't. Many folks in the electronic medical record environment don't know that every action they're taking is being recorded in the background of this medical record system. And you can ask for that audit log. There is not the audit log. There are audit logs, but what is common to be certified is that there must be at least an audit log report that memorializes actions taken in the electronic medical record and who took those actions and the date and time of those actions, right? So when you get an audit log printout, it looks a little, you always ask for it as an Excel spreadsheet so you can manipulate it and search it and reorganize it. But basically, there are a lot of things that will appear in an electronic health record. Well, there is a lot about your care that doesn't make it into your chart. Let me say it like that. There's a lot about your care that just doesn't make it into your chart, but it will be documented in the audit log of who accessed your chart. So for example, if your treating physician only looked at your history and physical for 32 seconds, logged in, logged out, and then prescribed something that was inconsistent with your history and physical, you'll have an indication of how much diligence they were doing in the background. So when you, yes.
We have a question.
Oh boy.
Does that also apply to standard transaction data requests made to carriers or payers?
The short answer is I can't say it with the confidence that I can say about user access in an electronic medical record, but I can't imagine any sophisticated system that, I'm presuming that's like those electronic data interchange things where you submit your CMS form for payment and with all that diagnostic codes and you get your payment back. But I believe it does. I believe it would in a healthcare environment like a major hospital. If people changed the diagnostic codes on the CMS form before it got sent off, there would be an audit feature in the background for that. So anyway, just be aware of that. You can ask for the user. There is not the audit log, but there is a audit log that you can ask for. And one of the new features of the Cures Act is that this is going to be one of the things that you're going to be entitled to get on request. So anyway,
can you give us an example of how you would use an audit log in a case?
Yes.
As a
nurse
litigator?
says, right. The nurse says, oh yeah, I was there at bedside and I did this. And the doctor said, I was down the hall and the nurse said that. And we ordered something at certain time and I phoned the doctor and he didn't come in. And then I remember administering this drug at such and such a time. Everybody's story is different. The audit log will pretty much call the balls and strikes on everybody's version of what happened. And including a lot of actions that are not in your medical record, like
something missing.
Yes, and in just a minute, we're going to talk about the target-rich environment that is the healthcare environment of information, of electronic information, but we're going to get to that in just a sec.
Okay.
So anyway, just be aware that there's an audit log in the background of your electronic medical record, and it documents all the activities of people noodling around in your chart. And when you hear a story about somebody sold, Matt Damon's surgical procedure from some hospital to a gossip magazine, they always get fired now because they all know who did it, right? We all know who did it. It's like,
so this would be like in relativity when you're looking at the history of a document.
Exactly, yes.
And you say, this person viewed it, this person changed the coding, this person added a comment, the old comment was this, the new comment was that.
It's exactly like that. If you work
so
in
even
relativity,
if they view it, you see it. Okay.
Yes. Here's another thing that y'all just need to be aware of that's out there, because it's an objection that you get sometimes when you're looking to get your adverse incident reports, and when you're trying to get information that is beyond just your electronic health record, but which, depending on your attitude, I think is part of your electronic health record. But most healthcare provider organizations have to have some kind of quality assurance function going on to maintain their accreditation with the Joint Commission that accredits hospitals the way colleges and universities keep their accreditation by meeting standards. Every 3 years or 5 years, every organization that wants to get Medicare and Medicaid reimbursement has to stay accredited, and they have to go through an audit and meet very high standards of their organizational integrity, including their quality assurance function. And so they keep track of adverse incident reports, and there's a thing they generically call a peer review, typically. And peer review is a process sometimes protected by state statute, sometimes not, just depends. But basically, if a nurse wants to raise his hand or her hand and say, man, we have a problem with Dr. Smith, and there's a problem, and this is what's happened on his last 3 surgeries, and we all got alarmed in the OR. We had to go get another doctor, and there may be who knows, a substance abuse problem or something going on. Or maybe he's not qualified to do a procedure that he's doing. They can raise their hand, hopefully without fear of retribution or retaliation, and trigger a peer review sort of audit where that committee of the hospital sits down, looks at the facts, maybe interviews the person at issue, and then either prescribes some follow-up training or some kind of intervention, or maybe worst case may terminate their privileges to practice medicine in that healthcare organization. And so typically there are public policy reasons that favor the confidentiality of that if it weren't confidential, it wouldn't occur with the candor and frankness that they want. So it typically is cloaked with a privilege. But adverse incident reports are generally mandatory. So it's a little different when there's a mandatory requirement to say, if something bad happened that involves patient safety, you need to report it. You need to have an internal organization where you can report an adverse incident and have them collected so that hopefully in the process of collecting and analyzing and reviewing adverse incidents, if there's a trend of it, we'll spot it. In 1998, a report from the National Institute of Health came out called To Err is Human. Very pivotal report, because the conclusion was that in 1998, we were losing about 98,000 people a year to medical accidents. So I'll just say that again. We're losing 98,000 people a year to medical accidents. And people challenged that and said that can't be right. And everybody went in and looked hard at that data, and it survived scrutiny. And so a lot of these electronic medical records we have now were put in place largely to address some of the problems that report identified, that not having an electronic chart was itself causing problems. So one of the things about that is that they passed an act called the Patient Safety Quality Improvement Act. You'll hear people object to your request and say it's a PSQIA. And it is, they create patient safety organizations, and the intent is, can we make a safe place for people to send their embarrassing, compromising, bad information so that it can be collected and analyzed in a constructive way? And so the act, when you create something, when you create some content for the purpose of sending it to a patient safety organization, a certified patient safety organization, it's patient safety work product, and there's a privilege associated with that. The reason this comes up all the time in this context of what we're about today is that people will take everything they do and also send it to a patient safety organization and say, I'd love to give it to you, but that's privilege because we sent it to a patient safety organization. And so we've never met one of those that survived scrutiny from a good electronic discovery sleuth, because invariably they are never for the single purpose of going to a PSO. If they're for a dual purpose, if there's one other requirement to collect that same information or the adverse incident report, it breaks the charm of that privilege. And so just be aware of that. Don't take that on face value when someone throws up that roadblock necessarily. And just some quick, drive-by hits here. We as electronic discovery folks, often are going to come into possession of protected health information, either knowingly or often unknowingly. And if one of your cell phone collections is ever a physician, you will invariably, inadvertently have someone's PHI swept up into that collection. And so the way you can protect the healthcare provider and protect yourself is that you should have a business associate agreement with that healthcare provider that essentially makes you, I'm going to just grossly paraphrase it here, but it brings you within the circle of responsibility. You then share the same obligations of the healthcare provider themselves for protecting that data. And it's your contractual promise to safeguard that protected health information with the same integrity and diligence that the covered entity or the person that gave it to you has.
So Chad, how does that practically present itself in litigation and discovery?
Right.
Getting
So
a business associate agreement.
Yeah. So if we are in a circumstance in our larger electronic discovery practice, not necessarily healthcare at all, and on the facts of the case, there is the substantial possibility that protected health information from a healthcare provider, a protected entity, could be collected or swept up. We execute a business associate agreement with that person. So if, for example, a physician is the subject of having their cell phone collected, we typically send that physician, or that entity, a business associate agreement where we contractually agree, and it's a requirement under old HIPAA, 1996 HIPAA, to have that relationship documented, that they're not just indiscriminately giving it away to someone, they're giving it to someone who has a business associate agreement with them, who has contractually promised to care for it in the same manner they have. And again, on the HHS website, it has the best model template agreement for a business associate agreement.
And then for e-discovery.
Yes.
So if you have collected a physician's mobile device, you've entered into this agreement, and so that data is now protected. And then is that data, are we talking about protective orders if for what's produced, or this is non-responsive data, but it might be protected? So what does that mean?
Yeah. So the first thing it means is that there has not been a HIPAA violation by virtue of them giving it to you.
That's so it's protecting them.
Mm-hmm. Okay. It protects them and protects you. So as a threshold issue, the transfer of that information from the healthcare provider to the e-discovery vendor, that act in and of itself is not a HIPAA violation if there's a business associate agreement in existence. There are other things that you better read the agreement carefully about what you're signing up for, but it's all in there. but you still need to perform contractually. It's not just a paper drill. But if you execute all those requirements, it protects the party you've collected from, and it protects you as well.
And it makes you, as the vendor, subject to HIPAA? Or are you just a contract? Are you just subject to your contract agreement?
I would say both. I would say both. You are the business. I'll put it this way: the healthcare provider is kind of. I'm going to be careful how I say this. I don't want to say vicariously liable for its business associates, but the healthcare provider typically, for many purposes, is responsible for the conduct of its business associates in the handling of this, or at least access to electronic medical records. And so, yes, I would say you are contractually bound just to meet the HIPAA requirements that are imposed on you for coming into possession of that. Yeah. And there are a lot of requirements, like, raising your hand and telling somebody if it gets lost, for example, right? So
we've got a question.
Yes.
Would that also apply to business associates, subcontractors, and
yes.
trading partners?
Yes. It all runs. In fact, there's the short answer is yes. As many links of privity as there are, right? So yeah.
Does this also impact productions, or you need a confidentiality order in place?
Good question.
Or a protective order in place, or
right? Good question. So two scenarios. One is, the typical scenario is that it's inadvertently swept up and it's not relevant or responsive to any request to produce. It just happens to be on the phone of a physician and she was in a car accident, for example. That'd be one scenario where it's just completely incidental, but it's there and it's likely to be there, and you need to do that business associate agreement. And so you would never, what the business associate agreement allows you to do as the vendor is review her cell phone and go, not relevant, not relevant, not relevant, not responsive, rather not responsive, not responsive. Oh, here's the thing we're looking for, her text messages coming out of the grocery store before the accident. And then, so that should never see the light of day, right? That should never see the light of day. If it is responsive information, then you are going to need either a protective order, as a minimum, a protective order, and it's just gonna and it's gonna have to be taken up. People can consent to have their PHI disclosed. Sometimes they have to consent to it if their damages put it at issue, for example. But that's going to have to come up on a case-by-case basis. But you should not just wing it out to the other side. And
so I'm thinking of something. The doctor is texting with her client and gets in a car wreck. I mean, with her patient and gets in a car wreck. Yeah,
that's you. We better.
The fact that she was texting is responsive. The content
is not. Shouldn't be. Should it? I'll put it this way. The content is protected health information.
And then you redact that content.
At least, right. So all that scenario, that's a phone call and a visit with a judge.
And when we're talking about the business associate agreements, you were saying with a vendor, but really there's going to be an attorney over all this, right? Mm-hmm. Mm-hmm. Because it's litigation. Yeah. So is the attorney's law office going to be a part of that?
There's an exception there are some exceptions for having this material come along in the context of compulsory legal process, but and that's probably probably a little beyond the scope of today, other than to be sensitive about your obligations about it. And if there's any doubt, there's no harm in making your law firm a business associate for that limited purpose of representing a healthcare professional, I would say. So that's that. Just want you to be aware of that and how to handle it. Get yourself a business associate agreement from the HHS website. And kind of the last topic I just wanted to do as an overview is it is mind-boggling. Look, if you ever get bored looking at paper documents, man, just go do some electronic health discovery in a healthcare environment. Most everything leaves digital residue. For example, in a big sophisticated hospital, every single thing leaves a digital breadcrumb behind that can matter sometimes, depending on the facts of a case. When we were talking earlier about when you ask for your electronic health record, what do you get? One of the things that the owner of the electronic health records have to do is they have to maintain a written document that says, this is what we consider the health record, and this is what you're going to get if you ask for it. Don't think you're not going to get everything. You're not going to get all the information about your care. So for example, every machine that's humming in a hospital is typically recording data, transferring data. If it's a pump administering medication, they typically have a printout. There are, fetal monitoring strips with machines and sometimes that data is saved. Sometimes only a selection of it saved, but the rest is left behind. Typically now, every healthcare practitioner, once they come on duty, they have a little chip card. And basically every time they pass into a patient's room, it's like when you go through the toll booth with your electronic, toll paying thing. It records, Nurse Smith walked into the room at this point in time. Nurse Smith left the room at this point in time. Oh, Nurse Smith was walking past the nursing station at this point in time. So people's locations are scrupulously
and so what you're
documented.
saying is that that's not part of the electronic medical record, but that can be discoverable in litigation.
Absolutely.
So that needs to be an RFP for those things. So how would you know what's
form
that
there?
RFP?
Right.
What would you ask for?
Yeah. So really the safest thing to do is to do information source discovery at the outset.
Okay.
And as you know, because it's our MO, that really when we're representing a requesting party, we start typically somehow, some way with collecting information about where the information is on the other side, right? We start to collect a notion of what are the sources of electronic information, what's available.
And so then, at a hospital, like you would be asking for maybe a data map from IT, or you would be asking for a 30p6 deposition for information sources relating to where are you keeping things, how is this hospital run, how is data collected at this hospital, what data are you collecting, where is it, where are you storing it?
Give you a great example, a thing they call the Pyxis machine, and I forget what Pyxis stands for. I think it's one of the original manufacturers of it, but for a long time, controlled substances and medications have been kept in something that looks like a Coke machine, and it's the place where drugs are stored on the floor, right? So sometimes there are kinds of controlled substances that there's just no time for a nurse to run down to the pharmacy and say, quickly, I need some, fentanyl to this breakthrough pain that we're having, or some emergency, nasal decongestant for a patient with asthma, but I got to get it right now. And it sits up on the floor in a Pyxis machine, and they have to put in their code. And like a vending machine, it records what, it scans what came out and all that. You don't get that in your electronic health record, but it is often pivotal. that record is there and you can ask for it and get it. But when you ask for your electronic medical record, that kind of source may not be what you're going to
So you
get.
have to be thinking beyond it. Now, we have 8 minutes left and I have some
Yes.
questions.
Yes, let's go with some. I've been yammering too long here.
Let's talk about e-discovery and discovering these electronic medical records and what you're going to get produced to you.
Yeah.
All right. So my understanding from past conversations is that different electronic medical record software would have different capabilities and different outputs. Now, what you've already told us today is that it needs to be certified if they were going to get their stimulus, if the doctor's office or hospital was going to get their stimulus for converting from paper to electronic. But there's different costs to these softwares. There's, like a hospital is going to be able to afford something a lot more than just your kid's pediatrician office. And so what should we be expecting to see? A bunch of PDFs?
Right.
Or what? Can we expect, what kind of metadata can we expect, and what should we be asking for? And if we have a form of production where we're going to be requesting form of production, what should we ask for? What is it? What are they capable of providing versus what might you typically see?
Yeah. So, you should always ask for an electronic format because it'll be searchable, and they can be outputted with the push of a button. They all have the functionality now of sending you a chart that has a PDF index and bookmarks and all that stuff. It's very similar to what, but it will not look like what the user interface was for the healthcare provider at the time, right? So a lot of times you'll get your chart and it'll say patient's skin integrity was cold and clammy, and his fingernails were purple. Well, that will come from a lot of times it's important. That came from a drop down of what were the 6 choices of how to describe that? Was that just the best answer? Maybe not the perfect answer, it's just the best answer? Or did someone affirmatively say, not pink, I'll call that purple, right? No, it's probably just a drop down, and you have to pick the best.
User error, like user error, accidentally bump the one above it on the drop down selection.
User error, and
somebody hand wrote purple skin.
But you also need the context of, do you take these things literally, or do you recognize them as probably the best answer of many, right? And if you look at notes from a surgical procedure, isn't it strange, gosh golly, that we had the same surgery, every 6 months, and the words are the exact same, and it's not strange, it's a template. And so the surgeon walks out and said, I just did an arthroplasty of the left hip. And she'll say, dictation machine, patient number so-and-so, I need paragraph 16, 24, 37, 14, and here's my entry for the little block on paragraph 91 when I say how much blood was lost during the procedure. And they're done, right? And you get a 14-page operative note that recites the perfectly executed operation, but it's a template. So you context matters, and sometimes you want to know what that context is. If physicians,
so how can we get the context when we're doing our requests?
You're going to have to do extra. You're going to have to do. You can do inspections where you get to sit down and see the user interface as the healthcare provider saw it. And so what they'll typically do is they have like a dummy physician and a dummy physician assistant and a dummy nurse, and or the permission levels for call it an avatar. Don't want to call them dummies, but let's say it's an avatar, right? And so you can sit down and request, I need to see what that user saw that day. and what were the choices and what other information was available at the time. And
so how do you document that? So it just makes me go back and think about relativity. And okay, I want to export, I've created this list and I've got these documents and I want these fields and I'm going to export that into an Excel, and I'm going to get a list of my documents and whatever fields I decided to pick. But that's nothing like being in relativity and being able to turn all the dials and things like that. So, so you as a lawyer, and we've got 3 minutes left, but you as a lawyer go in and you inspect that, but do you record what you looked at? I mean,
yep, you videotape it. You do. Yeah. Okay. And usually you get a minder, you get to sit there and there'll be an agreement ahead of time. And they'll say, you're going to get a minder, but this isn't a deposition, so you can't ask the minder questions.
It's like a proctor.
Yes, something. You can say things like, minder, I'd like now to go to the section of the chart called history and physical. And they'll go, fine, and they'll click on it for you. And you can ask them kind of questions like that. But if you go, well, now whatever, and they'll go, whoop, sorry, say that for your depo.
We have 2 minutes. So a question I would ask is, should you go ahead and you request the medical records, you get the export, you look at it, you study it, and then you request this session where you can, so you already have pinpointed areas where you want to look at, and you can go in and be efficient.
I'd say in any issue, in any kind of dispute where what happened is at issue, you have to get the audit log or an audit log. There are many audit logs. You can order up custom audit logs if you can get them, but you need an audit log of user interactions known, that are facially disclosed, right. And so and then a person that does this, you sit down in the chart and go, what made it into that? You should find the correlation of most things from the audit log in the chart itself. And when there's things that aren't there, or there's things that aren't there that aren't on the audit log, or vice versa, then you need to, pull the thread a little further and explore that and make sure that the integrity of everything is good.
Okay. So thank you so much, Chad.
Oh my God, I'm sorry I blathered so long, but there was, this just gives you, this was meant to be like, EMR's 101, and a real deep dive would take a couple of days, but just to know what the issues are.
And thank you for everyone in the audience for attending. I think customer service at aceds.org. If you have any questions, then you can find us on LinkedIn, and also the YouTube channel for ACEDS will have this recording posted if you missed anything or want some more information.
Thank you, Martin.
And are you going to share your slides? And
thanks, Alice. Good to see you. Yes, and
we can have ACEDS send them out to everybody who registered.
Chad.Roberts. Yep, I'll put my. Okay. And if you have any follow-up questions or templates, or you want to chat, just holler at me. Do it all the time.
Okay. Appreciate it. Thank you.
Thanks. See everybody.
Bye.